Capital Record, where we defend free enterprise and capital markets because we believe in the dignity of the human person. Hello and welcome to another episode of David Bonson's Capital Record, brought to you by National Review. And I think this topic today is a very simple one, but allows us to unpack a little bit some greater wisdom and logic in what we view about market transactions. I'm, of course, referring to a court ruling in the United Kingdom. All right, so this is in England. This is not the United States of America. I don't think America's gone this far down the path of insanity yet, but this is a real life suit with a real life finding that is going to be used here by us today in the Capital Record to unpack a greater lesson that is, of course, going to be rooted to first principles. I'm going to read you directly. First, the headline from The Guardian: senior staff can sue if given low status desk. UK tribunal rules. An estate agent who quit after being denied a symbolically significant seat had a right to view it as a demotion, the panel says. Straight from the law in England, this is a real estate agency moved a worker to a different desk. There was not a termination. There was not a lowering of pay. There was a different desk, and the person sued, and the tribunal ruled in their favor. And I quote, allocating a senior employee a desk they believe to be associated with a junior position amounts to a breach of workplace laws. An employment tribunal has ruled. The panel said being made to sit somewhere in the office where junior staff work could logically lead a senior employee to conclude that they've been demoted. As a result, such a seating arrangement could, quote, destroy or seriously damage, end quote, the worker's relationship with bosses and lead to a successful legal claim. The ruling came in the case of a senior estate agent who resigned because he wanted to sit at a symbolically significant desk. Symbolically significant is in quotes in the lawsuit. He had been asked to move a branch, but was upset when he was told he would sit at a middle desk rather than the back desk, typically where the manager sat. When his boss heard about the 53-year-old's resistance to the desk allocation, he said he could not believe a man of his age was making a fuss about a desk. He immediately submitted his resignation and is now set for a payout after successfully suing the firm for an unfair constructive dismissal. Okay? So essentially, getting a new desk was equivalent to being fired. If you think that this is so absurd that I'm wasting your time by bringing it up in Capital Record, you are only right in the first half of your thought. It is that absurd. But I have to bring it up in Capital Record because this is exactly the reductio ad absurdum that we face by those wanting greater intervention from third-party, disinterested state actors meddling in the silliness and trivialities of things like this that take place in workforce. The idea that moving one's desk amounts to a constructive dismissal is not something an adult can take seriously. The idea that the state needs to come in and rule, have a tribunal come in and rule as to whether or not this desk or that desk is appropriate for someone of their age and stage and whatnot, that those things are not best adjudicated between willing buyers and sellers. And in this case, what's being bought and sold is labor. Therefore, we're talking about employers and employees. The free parties freely exchanging, in this case, their own services, and in one case, the compensation for said services. Once you open the door to the idea that we need a higher regulatory apparatus whereby minutia and granular disputes over chair location, and again, we didn't get into chair comfort, amenities. Did you get a stand-up action? A lot of people want that these days. What kind of cushioning is available in the chair? I don't know anything about the view. I know he went from back to middle, but maybe the view, even if he went maybe to the side, there could be an impediment from the window situation. Maybe they move offices and the new office doesn't have the same amenities that another one did. And these things amount to a constructive dismissal. I could throw up. However, this is deadly serious because it is exactly what we have to look forward to. If we believe the need of the hour is, first of all, coddling adults around things like where their chair will be and their view and their amenities of this and that. This we've certainly set the table for a lot more of these kinds of cases going forward. What's particularly upsetting on this one is that this guy is 53 years old and he's a Gen Xer. He's supposed to know better. You expect this, I suppose, from a more entitled member of the population, but no, this is hideous coming from a fellow Gen Xer. But I will say this, in principle, it is logical. It follows logically. It tracks when you decide that what we need in these various commercial disputes, arrangements, discussions, negotiations is some form of third party arbiter to determine the value of a desk and what it amounts to. And somebody with no skin in the game, who's literally carrying the title of tribunal, to come announce that a desk being moved amounted to a unfair constructive dismissal. Um, we have passed the Rubicon here, and the only way to avoid this is not in this particular case to say, yes, we need greater state intervention in where people sit, but no, the state should have ruled differently. The only thing for the state to have done here is say, we're not going to render an opinion about where he sits and doesn't sit. That is between an employer and employee. And that the idea that in addition to compensation, which is heavily regulated, and benefits, which are heavily regulated, that now furniture and furniture seniority is now heavily regulated. I'm sorry, but if you're still taking this seriously, this is a lost cause. What happens now, to be more serious than me just picking at a person who obviously deserves something very different than what he got in Dave Land? What is going on here is that there is going to be a systemic downward pressure on the desire to hire people, to retain people, to deal with the complexities of managing human capital, human talent, personnel, that you make people more likely to let somebody go when you feel that it could lead to one day being in front of the furniture tribunal. My argument I've made time and time again about the more difficult we make it to fire people is all that happens in an economy of scarcity, which is to say an economy that is governed by trade-offs, is you make it harder to hire people. The harder it is to fire, the harder it is to hire. And these trade-offs that exist are universal. They are embedded in the very nature of things. And so we could argue about the prudentially poor decision that is made by this tribunal about the furniture location. However, what I would argue we're dealing with is setting the table for a continued environment that is negative for those who want to go to work, contribute to a company, help generate profitability, benefit from that themselves, and not be a pain in the you know what. That there becomes a greater resistance towards transacting in these types of situations. Companies have to bake in protective measures against running into a, shall we say, overly eager tribunal. There is always going to be a need for state action to secure the rights of those who would be put in unsafe work conditions, victims of fraud, corruption, theft, When we push this open when we open Pandora's box further to say, not only do we want the government to enforce contract law around wages, that you promised you were going to receive this and you haven't received it, therefore the state is there to secure that remedy. When we then add to it the discretionary intervention about furniture location, we have opened up a box that we do not want open. And this is where those of us that get called market purist, market fundamentalist, market orthodoxy, dying on the altar of the free market. No, no, no. All I'm trying to do is avoid a furniture tribunal. And there is no limiting principle that keeps you from ending up with this type of absurdity as a rather developed and sophisticated nation like the UK apparently is testimony to. That when you go down this path, that you have invited such state interventions in a market economy where it does not belong. You do not get a more virtuous society. They're not enforcing virtue. They're not enforcing something that is upholding of the common good. And then you have certainly gotten a less free society. So you need one to maintain the other. And when you sacrifice one, you inevitably sacrifice the other. Be very careful what you wish for when your goal is a state that is going to help determine things that is outside of their normal purview. I don't suggest, by the way, that all you have is a bright red line about enforcing contracts or compensation. I am in favor of that bright red line, but I am aware that there will be some disputes that involve a complexity and an ambiguity that the legal system is an appropriate venue for. I am suggesting, however, that the burden ought to be very high. And that when you make the burden so low that you end up having to actually hear a case about essentially whether or not someone's chair was in the right place, you have lost the whole deal. This whole thing is getting away from you real quick. And I believe that's what's happened in this case, but I believe it's happening in many situations in the United States. And I think a lot of our European friends are just ahead of us on this. The right situation, of course, is for market forces to regulate where people sit. That a gentleman can leave the company if he doesn't like where his chair is. And if the company manager doesn't want him to leave, they have an incentive to give him a good seat. And if he brings his talents elsewhere, the company suffers, so they don't want that. And if they wanted to get rid of him, then they can terminate. And to the extent that you start talking about furniture as a right, and that the court is going to say not merely you have to get paid what you were promised, but that you are going to be positioned in various places in the company. I think that at that point, it would be very difficult for a sensible person to argue that that's inside of the lines of what we're trying to protect here. So the agenda I have in protecting a free society is indeed to protect companies from this type of litigious and abusive, disgruntled employee. And I am trying to protect uh, companies from this type of, I think, abusive tribunal. But I'm also trying to protect future employees, not just the employer, from a system in which their rights and freedom and good faith of negotiation are going to be significantly hindered. The trade-offs in this case are brutal. And it just so happens that we don't only need to be opposed to this because of what it would lead to, but what it actually is in and of itself, which is a patent absurdity. But even apart from that, what this leads to is bad for employers, employees, and the economy at large, which is to say, the customers of the business. Everybody suffers when you have to be worried about whether or not the state will approve of your furniture layout, of what cubicle employees have gone in. This is a clear area in which those who are incrementally looking for a little greater state involvement need to take a beat. And if we come across an area of grayer ambiguity, of more legitimate complexity, let's have that discussion prudentially. But first principles and common sense tell us that this is a bad road we are on. Thank you for listening to David Bahnsen's Capital Record. Be with you in a couple of days.